your case today. If you are charged with a first-degree misdemeanor, the maximum sentence which could be imposed would be 1 year in jail and a fine of $1,000 plus court costs. If you're charged with a second-degree misdemeanor, the maximum sentence which could be imposed would be 60 days in jail and a $500 fine plus court costs. The minimum sentence which could be imposed for charges other than DUI would be a sentence where the court withholds adjudication of guilt and imposes court costs. If you're charged with driving under the influence, the maximum and minimum sentence you are facing will depend on a number of factors, including any prior DUIs you may have, how often they have occurred, if you caused an accident, and your alcohol level at the time of testing. These maximum and minimums are explained on the blue form that has already been given to you. If you enter a plea of guilty or no contest to a DUI charge, the law requires that you be adjudicated guilty of the offense. In addition to the maximum and minimum sentences you may be facing, you may be placed on probation with conditions requiring you to satisfy terms of your sentence, such as paying fines, costs, and restitution. If you fail to satisfy the conditions of your probation, you may be arrested, and if the judge finds you in violation of your probation may be revoked, and you may be sentenced to the maximum sentence allowed by law. When you stand before the judge, it will be necessary for you or your lawyer to enter a plea on the charges to the court. This is the plea stage. There are 3 types of pleas that you can enter: not guilty, guilty, or no contest. A plea of not guilty means you are denying the allegations and the charges against you, or that you want the state to prove the guilt beyond and to the exclusion of every reasonable doubt. A plea of guilty means that you are admitting your guilt. A plea of no contest essentially means that you do not wish to contest the charges which the state has brought against you. While a plea of no contest is not an admission of guilt, it tells the court that you wish to enter a plea and be sentenced because you feel it is in your best interest to do so. The legal result of a no contest plea is the same as a guilty plea. When making the decision on your plea, please disregard any advice that other inmates or anyone else who is not your lawyer may have given you about the possible outcome of your case. Please understand that if you plead either guilty or no contest, and the court finds that there is a factual basis for the charges, the court may adjudge you to be guilty and impose a sentence. The court may also, in its discretion, withhold adjudication of guilt on either a plea or judge. The right to have the assistance of the lawyer through all proceedings, including pretrials, hearings of motions, and trial. The right to compel the attendance of witnesses to testify for you or on your behalf. The right to confront and cross-examine any witnesses who could testify against you. The right to remain silent, and the right not to be compelled to incriminate yourself. The right to require the state to prove your guilt beyond and to the exclusion of every reasonable doubt. The right to appeal any matter pertaining to the judgment and sentence in the case. When your name is called, please come forward. The judge will advise you of the charges against you. In some situations, the judge may advise you of the sentence or disposition that will be imposed if you enter either a plea of guilty or no contest. The court will also ask you if you want an attorney appointed, or if you want to represent yourself, or if you plan to hire an attorney. If the court appoints a lawyer to you, you will have an opportunity to talk with the lawyer today. You or your lawyer should advise the judge whether you wish to plead not guilty, guilty, or no contest when asked. If you plead not guilty, the court will pass your case for a pretrial hearing at another time. You will be advised by the judge which courtroom you must report to for your next court hearing. The court will also consider the facts of your case, your prior record, and any other information that may be available in setting reasonable conditions of release that will reasonably protect the community from risk of physical harm to persons, assure your presence at trial, and assure the integrity of the judicial process. These conditions may include anything from releasing you on your own personal recognizance to more restrictive conditions, such as imposing restrictions on your travel, restrictions on your association with others or places where you may reside, placing you in the custody of a designated person or organization which agrees to supervise you, requiring that you wear an electronic monitor, or requiring that you post a bond. In sum, the presiding judge will consider all available relevant factors to determine which form of release would be necessary to assure your presence at any future court appearance. If a bond is set and you post the bond, you will be released from custody until your next court date. If you are unable to post your bond, you will remain in jail until your next court date. If you fail to appear for any of your court dates, a capias or warrant will be issued for your arrest. If it is your decision to resolve your case today by pleading guilty or no contest, the court will usually impose sentence immediately. In some situations, your case may be passed to another date for sentence to be imposed. Please do not enter a plea of guilty or no contest if you feel threatened or coerced, or feel that special promises have been made to you out of court. You should also not enter a plea of guilty or no contest if you feel that you have not had enough time to consider your plea or its consequences. You should also not enter a plea of guilty or no contest if you're under the influence of drugs, alcohol, or medication to the extent that it affects your ability to understand what you are doing, or if you don't understand everything that is occurring in the courtroom. If you are sentenced today, the court must impose certain mandatory fines and court costs. The court may also impose certain discretionary fines and court costs. You will not need to pay the fines and costs today. When you are released, you will be given a written form that contains the amount of fines and costs you owe and a due date set by the court. In the event that you cannot pay the fines and court costs by that date, you may request an extension or payment plan from the clerk of the court. If you fail to pay on time and do not arrange for an extension or payment plan through the clerk, your driver's license may be suspended. Please understand, if you are not a United States citizen and you enter a plea of guilty or no contest to a crime, you may be subject to deportation from this country and prohibited from re-entry pursuant to federal laws and regulations, even if the court withholds adjudication of guilt. Also, please understand that if you plead guilty or no contest, and the offense to which you are pleading is a sexually violent offense, or a sexually motivated offense, or if you have been previously convicted of such an offense, a plea could subject you to involuntary civil commitment as a sexually violent predator upon completion of your criminal sentence. If you are sentenced today, you will have 30 days to appeal the judgment and sentence of the court, and if you cannot afford an attorney, one will be appointed for that purpose. However, please understand that if you enter a plea of guilty or no contest today, you would not be able to appeal any matters related to the issue of your guilt or innocence. You would only be allowed to appeal the legality of your sentence and whether these proceedings have been conducted in a legal fashion. When you hear your name, please step forward.
All rise.
And we'll do our calling and all right, now session. The Honorable Judge Colin is presiding. If you're not walking to the courtroom, you're going to raise your right hand to the podium by the clerk.
You all be seated.
Okay, good afternoon. This is the Criminal Division in for Division I. My name is Judge Drake. I'm the presiding judge in for this division. Shortly, I will be calling your names and ask that you come and stand in front of the brown desk. We do have some private counsel and some other things we're going to take care of first. And then I will explain some very important constitutional rights to the rest of you. If you are here, if you're charged with a felony, this is called your first appearance. The purpose of first appearance is to determine whether or not there is probable cause to detain you in the Duval County Jail. That means that I must read and look at all the information that's contained on the back of the arrest and booking sheet. If I read that and there's enough information, you will hear me say, the court finds probable cause to detain you. Another thing that I must determine is a reasonable bond. A bond is set based on the severity of the crime, your ties to the community, whether or not you're on probation, whether or not you have any failure to appears, whether your likelihood of a flight risk, and any other information that's contained in your file. And as such, I will be asking the bailiff to hand me your jail jacket. As you can see, some of them are quite thick and some of them are thin. So it is quite possible for two individuals to be charged with the same or similar crime and in fact have different bond amounts. Another important constitutional right, I will be appointing the office of public defender to represent you if you cannot afford an attorney. If private counsel, or you intend to hire private counsel, you may tell me that. Also, another very important constitutional right is the right to remain silent, which means that anything that you say can and will be held against you in a court of law. There's a court reporter sitting in front of me who is taking down everything that I am saying, and consequently she will also be taking down any statements that you make in court. At this point, because this is your arraignment and your attorney does not have any information to really give you reference your case, and it's the state's burden to prove its case against you beyond a reasonable doubt, please do not make any statements to this court. There are some exceptions to setting of a bond. This means that if you are here because you were arrested on an arrest warrant, that means that an officer went before another judge and swore that the information contained in that arrest warrant was true and accurate. That judge had the opportunity to ask that officer questions, review your record, and that bond has already been set. This court will not be disturbing that bond because at that time I don't have that same kind of information available to me. However, this does not mean that your bond cannot be changed. And if you believe that your bond is too high, then you should consult with your attorney. And if your attorney believes that it is appropriate, then the attorney will file the appropriate motions in your particular case. So we're going to do the first appearances, and we're going to do some a little out of appearance here. I think we have individuals from RCC already here, and Mr. Manti, are you here also? Okay, so let's go ahead and let's do this one. Yes. Okay. Ms. Barton, you're charged with child neglect as a third-degree felony as the first count, and count 2, giving false information to a law enforcement officer in missing person less than 16 years of age investigation. This bond has, the probable cause has already been reviewed. There is an arrest warrant that was signed by Judge Gooding. You have a copy of the warrant. Judge Gooding issued a warrant for your arrest on August 18th, 2015. He has set the bond in each case at $25,003. The RCC is present and will be representing you. There is a conflict which I've been advised from the Public Defender's Office. He will be speaking to you about your case. Your pass date is 9/9 at 9 o'clock in Circuit Court. Thank you. You're welcome. Okay. Do we have private counsel at this point also? Ms. Gornfield, who do you have? Did you check with to pull it out of order? did. Yes, you may.